Hello friends, today's newsletter dated 2nd April 2024. The first news is about a particular case under the Negotiable Instrument Act regarding the interim compensation. The Supreme Court, actually in this particular matter, a matter came before the Supreme Court from Jharkhand High Court, where the Jharkhand High Court has ordered a payment of 10 lakhs rupees as an interim compensation in the matter under the section 143A of the NI Act. Now the thing is that Supreme Court says that the ways High Court has interpreted the section where in the 143A it is written that the word is that interim compensation may be given, but where the High Court actually strictly construed it and interpreted that may should be construed as shall, and which the Supreme Court completely differed with the High Court opinion, and they also set out 3 guidelines in this regard. The first guideline is that there should be, in order to give a interim compensation, there should be that a prima facie case on the behalf of the complainant that like the accused person is willfully defaulting the particular payment. The second is that the accused person's financial condition. From time to time, the accused person's financial condition may be very bad, and that has to be taken into consideration, because that's why maybe the reason the accused person was not able to repay the particular amount, and that's why the check was bounced. And lastly is that if there is a possibility that if the accused person has a like a proper defense, like any other defense also, that has to be taken into consideration while granting the interim maintenance. So in a laconical manner, if this kind of order is passed, that is violation of the natural justice, and also this is actually a hindrance and a bad interpretation of that particular section, and that actually Supreme Court stated in this particular case, which is a very important case. Now coming to the second news, the Supreme Court is going to see the legitimacy of the Muslim women's divorce by khula. So khula is a particular process in the Muslim women's divorce where the Muslim woman can unilaterally divorce any male husband without getting any kind of consent or note from it. And in this regard, the Kerala High Court has given 2 judgments in the 2021, and that judgment was again reiterated in the 2022, and which came by the SLP before the Supreme Court. And in this SLP also Supreme Court condoned the delay, and they accepted to review this particular matter. Now coming to the third news is that Supreme Court vehemently reviewed the Patanjali and its manager, and for a particular matter. This is regarding a matter by the Indian Medical Council, where they have argued that the way the Patanjali actually misinform and misrepresent their product in various ad, and that does not have any kind of scientific basis, and that is violation of the consumer norms. So in this regard, the Supreme Court has previously directed to stop those kind of misleading advertisement, which was not stopped. And later on, when the Supreme Court actually gave some strict, there was a contempt notice in this regard. In this particular contempt, the Supreme Court directed them for a personal presence, Baba Ramdev and the manager in this regard, Patanjali, but they did not actually appear in the person, but they actually provided a particular apology particular affidavit before the Supreme Court, where they stated that their media arm were not aware of this particular judgment, which the judges took a stern notice stating that they do not believe in that statement, and they told them to come with a better apology and affidavit, and also they told in the next day hearing the Ramdev and the manager of the Patanjali has to be present in this regard. Now, the Supreme Court has granted bail to the Aam Aadmi leader Sanjay Singh in the Delhi liquor policy case, and this was due to the fact that ED did not ask for an extension of their custody in this regard. The Supreme Court has directed the states and union government that existing group of advocates in any kind of government and state panels, they should be written for at least 6 weeks post any kind of government change, and once the new panel is formed, the old panel should be retired. Otherwise, there will be a lot of cases of adjournments in the matter, and that will be an impediment to providing justice. So this is all about the today's news. I hope you like it, and so like and subscribe and comment in this regard. Thank you.